Hello all, welcome you to the course on corporate laws and governance. In this video, we are going to look at the Consumer Protection Act 2019, and we will also learn about the redressal system that is available under the Consumer Protection Act. Before the Consumer Protection Act 2019 was there, we had the Consumer Protection Act 1986, which was there for more than 33 years. It got amended at various time period, like it got amended in the year 1991. Again in 2002, the Consumer Protection Act 1986 saw some amendments due to the changes that was happening in the economic environment. We had liberalization, privatization and globalization happening in the economy, as a result of which the law had to be changed according to the needs of the changing economic scenario. Though they were making changes in the Consumer Protection Act 1986, there were still few lacuna which couldn't be covered by the Consumer Protection Act 1986, especially due to the digitalization of the entire economy as such, which changed the way the relationship between the seller and buyer exists. As a result of which, the government passed the Consumer Protection Bill 2019 on 6th August 2019, and this particular bill got approved by the President, and Consumer Protection Act 2019 came into force on 20th July 2020. Now let us see what are all the salient features that we have in the Consumer Protection Act 2019. If we look at this Consumer Protection Act 2019, it is pretty broader in its scope in comparison with the Consumer Protection Act 1986, because it deals with the unfair trade practices, in the sense the scope of the unfair trade practices got extended. This particular new act talks about, or it has included, the provisions for e-commerce. It also started giving importance to misleading advertising, telemarketing, etc. So if we look at the scope of the Consumer Protection Act 2019 is pretty broader in comparison with the earlier one. The next important feature of the Consumer Protection Act 2019 was that it includes the e-commerce. In fact, this particular act came out with the definition for the term e-commerce for the first time. As per this particular act, e-commerce involves the buying and selling of any goods or services, including the digital products, through the electronic mode or the digital mode. So this e-commerce got included in the Consumer Protection Act only under this act. The next feature that this particular act has is that this act has broadened the definition of the consumer, because this particular act talks about telemarketing, it talks about the multi-level marketing. It is not only about the offline and online, this has also included other types of marketing which has an impact over the relationship between the buyer and the seller, like the telemarketing and multi-level marketing. If we look at the pecuniary jurisdiction under the Consumer Protection Act, it got changed in the Consumer Protection Act 2019. In Consumer Protection Act 1986, if a consumer wants to file a complaint, they have to go to the district commission if the price that they pay for the goods are up to 20 lakhs. They will have to go to the state commission. If the price that they pay for the goods fall above 20 lakhs, and if it goes up to 1 crore, if the price that they pay for the goods are going to be more than 1 crore, they will have to go to the National Commission. This was the provision that was there in the earlier act, but this pecuniary jurisdiction got revised under the new Consumer Protection Act 2019. As per this, the consumer should file the complaint with the district commission if the price that they pay for the goods are going to be up to 1 crore. When the price that they pay for the goods are going to be above 1 crore, and when it is going to be within 10 crore, they will have to go to the state commission. If the consideration that they pay for the goods is going to be more than 10 crores, then they will have to go to the national commission. So this pecuniary jurisdiction got revised under the new Consumer Protection Act 2019. Next is to do with the flexibility in place of filing the complaint. If we see the earlier act, if at all there is a complaint for the buyer, then they can actually make the complaint only in that district or only in that state where the seller resides or has a branch, or he has his commercial activity taking place there. But now it has been revised. The consumer can file the complaint with the district commission or with the state commission where he or she resides. So this is a change that has happened under the Consumer Protection Act 2019. Now this new act has provided this e-filing of complaints. Not necessarily the filing should be done in person or through post. Now filing of the complaints can be done with the district commission or the state commission or the national commission for that matter through the online mode, wherein the consumer is expected to follow the procedures which the forum wants them to do. This new act has led to the establishment of the regulator for the consumer protection. We call this as the Central Consumer Protection Agency. If we look at the role of this Central Consumer Protection Agency, they are there to protect, to promote and to enforce the consumer rights. The other salient features that we have is the broader meaning of unfair trade practices. Of course, we had unfair trade practices got covered under the Consumer Protection Act 1986, but if we look at this new act, the Consumer Protection Act 2019, they have even included that the seller is not supposed to divulge any personal information that a buyer has shared with him unless and until that they are allowed to share it under the provision of any other law. So if there are any sensitive informations, personal informations that have been given by the consumer to the seller is not supposed to reveal it to others. In case he or she is going to reveal it, then it falls under unfair trade practices. The next feature of the new Consumer Protection Act 2019 was the introduction of mediation in order to resolve the consumer grievances wherever possible. If the grievance can be resolved through mediation, the Commission will refer that particular matter for mediation. This provision actually helps in the speedy redressal of the complaints of the consumers. That is one advantage of it. Next is it also reduces the pressure that the Commission has in resolving the grievances. So these are all the two major advantages that the Consumer Protection Act gives through the introduction of mediation. The next important feature that we have under the Consumer Protection Act 2019 is product liability. This product liability is based on the strict liability principle, wherein the consumer can ask for compensation for the damages that he or she has to undergo because of the defects in the product. So this is one of the new addition to the Consumer Protection Act. The next what we have is to do with the power of review. under the old Consumer Protection Act 1986, review of the judgment can be done only by the National Commission, but this particular act has given the power of review even to the State Commission. Next is to do with the penalties. If we look at the penalties under the previous act, the penalty for the guilty would be the imprisonment, which may range from 1 month to 3 years, and the fine that the guilty may have to pay, it may range from 2,000 rupees to 10,000 rupees. Now this has been changed under the new Consumer Protection Act 2019. Now, if we look at the imprisonment for the guilty, it may be up to 3 years, and the fine amount had been changed, and it should be not less than 25,000 rupees, and the fine can go up to 1 lakh rupees. And next, what we have in the new Consumer Protection Act 2019 was the increased timeline for filing an appeal against an order. Appeal is normally done by the consumer when they are not happy with the verdict of the lower court. In this case, if the consumer is not happy with the judgment of for that matter, not only the consumer, any of the parties, it could be opposite party or the complainant for that matter, if one of the parties are going to be unhappy with the verdict of the district commission, they can make an appeal to the State Commission. Previously, under the old act, they have to do this appeal within 30 days from the date of such order. Now this has been changed into the new act, wherein they can do it within 45 days instead of 30 days from the date of getting such order from the District Commission. This is another change that we have under the Consumer Protection Act 2019. Previously, the pecuniary jurisdiction was calculated only on the maximum retail price, but under the new Consumer Protection Act, the pecuniary jurisdiction are calculated based on the purchase price or the discount price which the consumer has paid. Next, let's look at the Consumer Protection Councils. We have the Consumer Protection Councils at the center, state and at the district level. And what is the purpose of this Consumer Protection Council? The purpose of this Consumer Protection Council is to review the policies of the government which are there to protect the consumers. If you look at it, the role of this Consumer Protection Council is pretty advisory in nature. So what they would be doing is they would be reviewing the policies of the government with respect to the protecting the consumer, and wherever they could give suggestions, they give the recommendations for the improving the policies that are there to protect the consumers. So the idea of it is to promote the rights of the consumer, and in the sense they want to enforce the consumer rights, and the consumer grievances should be redressed in the timely and effective manner. So we talked about this Consumer Protection Council at the center, state and the district levels. At the central level, the minister in charge of consumer affairs would be the chairman. Of course, we will be having the other official and non-official members in this particular council. And the minister in charge of consumer affairs in the state would be the chairman of the State Consumer Protection Council. And in the case of district level center, so we would be having the collector of the district acting as the chairman. And as we have already seen, these councils play a role of an advisor with the purpose of protecting, promoting the consumer rights. So that is the basic idea of this Consumer Protection Councils. Next, let's look at the Consumer Disputes Redressal Agencies. We do have a 3-tier system of Consumer Dispute Redressal Agencies. So we have at the national level, district level, as well as at the state level. So at the district level, we have the District Consumer Dispute Redressal Commission. At the state level, we have the State Consumer Disputes Redressal Commission. And at the national level, we have the National Consumer Disputes Redressal Commission. Let's look at each of this Dispute Redressal Commission one by one. If we look at this district commission, every district in a country will have the district commission. We will have a president. The president should be qualified to be a district judge, and there should be a minimum of 2 members in this district commission. And in this commission, at least one person should be a woman, which is mandatory. They would be taking up the consumer complaints if the value of the goods or services paid as the consideration by the consumer does not exceed 1 crore rupee. So that is the pecuniary jurisdiction of the district commission. Every state in the country will have the state commission. Again, we have a president who is or has been a judge of a high court, and there should be a minimum of 4 members. One of the person in the state commission should be a woman. They would be taking up complaints provided the value of the goods or services paid as consideration by the consumer exceeds 1 crore rupee, but it does not exceed 10 crore rupee. They also take up complaints with respect to unfair contracts. They take up appeal against the orders of the district commission. If any of the parties is not happy with the judgment or the verdict of the district commission, they can appeal to the state commission within 45 days from the date of getting such order. Let's look at the National Commission. We have the National Commission in New Delhi. Of course, there is a president who is or has been a judge of the Supreme Court. There should be a minimum of 4 members, and this commission also should have a woman member. They would be taking up cases where the value of goods or services paid as consideration by the consumer exceeds rupee 10 crore. They also take complaints against unfair contracts. And of course, if any of the parties are going to be unhappy with the judgment or the verdict of the state commission, they can file an appeal to the National Commission within 30 days from the date of receiving such order. In case somebody is not going to be happy with the National Commission, what they can do is they can go to the Supreme Court and they can fight out. Next, let's look at the jurisdiction of the Consumer Commission. Here, which commission should the consumer reach out to whenever they have a complaint? They can lodge their complaint with that commission where the opposite party resides, carries on business, or has a branch office, or personally works for gain. Or else the consumer can also file a complaint where the cause of action wholly has arisen or it has arisen in part. They can also raise complaint wherever with the commission wherever the consumer resides or personally works for gain. Nowadays, not necessarily they will have to go to the commission in person to make a complaint. They can also go for e-filing. They have to follow the procedures that had been prescribed by the Consumer Protection Commission for e-filing. Whenever a consumer makes a complaint, the consumer has to pay a fee for it. They will have to take a demand draft, a cross demand draft, and they will have to, or they can even go for a Indian postal order. Both demand draft and the Indian postal order should be crossed. Demand draft has to be taken in a nationalized bank, and they have to take this demand draft or the Indian postal order favoring the registrar of the state commission or the registrar of the national commission or the president of the district commission, and they will have to take this demand draft or the Indian postal order at the place where the commission is located. So this is one way of paying the fee and making a complaint, or else they can even make the payment through the electronic mode. They can do that. If we see this particular table, we can understand that if the consideration that had been paid by the consumer towards the value of the goods, if it is going to be up to 5 lakhs, there are no fee involved. So there are different slabs available here, and the fee goes up to 7,500 rupees, and the 7,500 rupees is the fee only when the value of the goods paid as consideration by the consumer exceeds 10 crore rupees. So by and large, it is pretty nominal. Let's look at what are the procedures that are there to file the complaint. Whenever the consumer makes a complaint, they not necessarily that they will have to go for a bond sheet and all. They can write the complaint in a plain sheet. They can give the declaration, not necessarily in the stamp paper. It can be done in a plain sheet. They will have to give their complaints. They have to prepare the complaints, and they will have to give 3 sets if they are going to make the complaint with the district commission. Again, 3 sets when they make a complaint with the state commission. They will have to go for submitting 4 sets when they file the complaint with the national commission. Along with this, what they have to do is they will have to have additional sets depending on the number of opposite parties. If the number of opposite parties are going to be 3, then they will have to prepare 3 more sets for the opposite parties. So this is one of the things that has to be kept in mind. And when they write the complaint, there are certain things which they will have to divulge, like they will have to give the name and the complete address of the complainant. They will have to give the names and the complete address of the opposite parties against whom they are raising the complaint as such. They will have to talk about the price that they have paid for the goods. They have to give the particulars of the goods or the services availed, like they have to mention the number of goods that they have bought. They will have to clearly state under which category they are making a complaint, like does it fall under unfair trade practices, or is it about defect in the goods or deficiency in the service, or is there a complaint with respect to excessive charging of price. So this category of complaint should be clearly mentioned in the complaint by the complainant. They have to attach the cash memo or the bill or the receipt as the proof. And they will also have to have proof, evidences for the complaints that they are raising against the opposite party, all the relevant documents, copy of the documents, which would be actually giving more information about the complaint should be attached along with the complaint. And this should be signed either by the complainant or it can be signed by the agent through which they are filing the complaint. So we can see, like, not necessarily that they have to hire a lawyer. If they want, they can present their case on their own and they can sign the complaint. If they are actually going to raise the complaint through an authorized person or an agency, that authorized person or the agent would be signing it. And nowadays these arguments or case proceedings even happens through video conferencing. Next, let's look at what are the provisions that are there with respect to appeals. If if one of the parties in a particular case is unhappy with the verdict of the district commission, they can appeal to the state commission. They will have to make the appeal within 45 days from the date of receipt of such order. If one of the parties to the case is not happy with the judgment of the National Commission, then they can go file an appeal petition with the National Commission within 30 days from the date of the receipt of order. If a person is unhappy with the verdict of the National Commission, then appeal petition can be filed with the Supreme Court of India, and this appeal has to be done within 30 days from the date of such receipt. What is the timeline within which the complaint has to be filed? We have a timeline within 2 years from the date of the cause of action, or from the date of cause of the defect, or from the date of cause of the deficiency in service, they will have to file a complaint. In case somebody is going to file a complaint after 2 years from the date of the cause of action or the defect of goods or the deficiency in services, they can still do it. Only thing, the commission should be convinced with the reason for the delay in the complaint. But as per the rule, one has to make a complaint within 2 years from the date of cause of action or the defects in goods or the deficiency in service. Normally, second appeal is not allowed, and it would be allowed unless there is a substantive question of law involved. Otherwise, second appeal is not allowed. We have a nodal agency for the consumer protection. The Department of Consumer Affairs is the nodal agency for the consumer protection. If you look at the purpose of this nodal agency, they want the consumers to make informed decisions. They want to ensure that the consumers get fair, equitable and consistent outcomes out of their grievance redressal. They also want to ensure that the consumer grievances are redressed in the timely and effective manner. And they are seeking to achieve the above stated purposes by empowering the consumers through awareness and education, by enhancing the consumer protection through prevention of unfair trade practices, and by enabling quality assurance and safety through standards and their conformity. And they want to ensure access to an affordable and effective grievance redressal mechanism to the consumer. Next, let us look at some of the landmark judgments that had been made by the commissions. First, let us look at the case of Shri Dibakar Bhattacharjee versus the Airport Director, Airport Authority of India, and Air India and others. In this particular case, if we see, the complainant had booked a air ticket from Kolkata to Delhi, and they in fact travelled through by Air India. Once they reached the Delhi airport, their baggages were missing and they couldn't locate the baggage. So as a result of which, the complainant had to miss the official duty, and they had to undergo financial loss because of that. When the Air India wanted them to give them details about the baggages, at that time they couldn't give the exact details about it, and the Air India in fact told them to come with a detailed complaint through email, which they did later. So though they gave the complaint, though they were following up with the Air India, the baggages were never found. So what the complainant did was, the complainant went with a complaint with against Air India as well as against Airport Authority of India, because they felt though Airport Authority of India is not directly involved in the taking care of the transit of the baggages, still they felt like they also have the responsibility of ensuring that the goods or the baggages reaches the passengers without any hassle. But when the commission looked into this particular matter, what they did was like they came out with a judgment that the Air India and others have to pay a compensation of 2 lakh rupees to the complainant, and they asked the opposite party even to pay rupees 10,000 towards the litigation charges that the complainant had to pay. But what the commission did was that though the commission agreed that there was a deficiency in the service by Air India, but they quashed the complaint against the Airport Authority of India. They felt like Airport Authority of India is not responsible with respect to this particular deficiency in service. Next, let's look at the case of Jitendra Kumar Karsandas versus Union India. In this particular case, the complainant had 4 monthly income scheme with the opposite party, and if we look at this the complaint, what the complainant felt was like the opposite party pre-closed all the monthly income scheme, all the 4 monthly income scheme which the complainant had with the opposite party prematurely, without getting the consent from the complainant, and the entire amount was withdrawn and it was transferred to a bogus account. Actually, the opposite party cannot allow withdrawal of any amount above 20,000 rupees. If at all anybody wants to withdraw amount beyond 20,000 rupees, they will have to do it only through the check transaction. But here the opposite party allowed for the withdrawal of money which actually amounted to 4,73,000 and odd, and this in fact was transferred to a bogus account. So when the complainant went to the consumer court felt that there was a complete negligence of work as well as deficiency in the service by the opposite party, and they asked the opposite party to pay back the 4,80,000 rupees, which was the maturity value. Along with that, they wanted the opposite party to pay 15% interest on this 4,80,000 rupees right from a particular date that the forum has mentioned, and this simple interest of 15% will come down to 9% if the opposite party would be returning this 4,80,000 rupees within 60 days from the date of this verdict. But the opponent parties felt that the interest rate that was given as the penalty was very high. So what they did, they went for an appeal. They made an appeal to the State Commission, and the State Commission, though they went with the other penalties like giving back 4,80,000 rupees to the complainant, but they reduced the interest rate from 15%. They made it to they made it to 6%, because whenever the interest are charged, it should be equivalent to the interest that an individual would be getting from the savings account. If we look at the case of Citibank Home Loan Department and Ramesh Kalyan Durg and another, if we look at this particular case, the complainant had gone for a loan with the Citibank. In fact, the complainant had given the sales deed and other relevant documents in order to avail the loan. But what Citibank Home Loan Department did was like they actually missed the sale deed and other documents that had been submitted by the complainant. So the complainant had to go to the consumer forum. When the consumer forum looked into the matter, they termed this as negligence in service as well as deficiency in the service by the bank. And what they did was like they ensured that they have to pay, the Citibank has to compensate the complainant for the negligence, as a result of which they had to pay a compensation of 10,000 rupees. Along with that, they were made to come with an indemnity for 10 lakh rupees. This indemnity is for the misuse of the sale deed. In case in future, if somebody is going to misuse the sale deed that got missed in order to avail the loan or from creditors or any other financier for that matter, only the bank is responsible for that. Only for that sake, the bank was told to come with an indemnity for 10 lakh rupees if there is going to be any kind of misuse of the sales deed by any other party. So, and not only that, even the litigation charges of the complainant had to be borne by the bank. Next, let's look at the case of Pratibha versus the manager Canara Bank and others. This particular case, the major issue that this particular case had was that whether a trust can file a complaint with the Consumer Forum, because as per the Consumer Protection Act, a trust does not fall under the definition of consumer. So a trust cannot make a complaint, but when the trust went for an appeal, so it was clearly told by the State Commission as well as by the National Commission that a trust is not the consumer as per the definition of the Consumer Protection Act, and they cannot file a complaint with the Consumer Forum in order to get their grievances redressed. When this case was even taken to the Supreme Court held the decision, upheld the decision of the National Commission and told that a trust cannot be considered as a consumer and they cannot file a complaint with the Consumer Forum for any of their grievances. Now let's look at the case of HDFC Bank Limited versus Hemant Narayan Devande. If you look at this particular case, the complainant had the credit card, and there were transactions in the credit card in purchasing a product in Amazon. So the purchase was made for around say 37,000 rupees. So the bank, when they wanted to actually authorize this particular credit transaction, what they did was they made a call to the complainant asking whether the complainant did make a purchase or can they go ahead approving this credit transaction. But the complainant clearly told that he did not do any kind of transaction with Amazon for that particular amount, and and they even despite the complainant telling that no such transaction happened, the bank went ahead with sanctioning that particular credit transaction. So when the complainant did not make the payment, what the bank did was the bank put penalty, and they actually debited the other account of the complainant to around 41,000 rupees. So the complainant went to the Consumer Forum. The Consumer Forum felt that there was deficiency in the service of HDFC Bank. In fact, when HDFC Bank made a call to the complainant clearly told that he did not do any kind of credit transaction with Amazon. So the bank must have at least checked whether who actually misused that particular transaction, what was the address of delivery of that particular transaction. They could have investigated into the matter instead of authorizing and clearing the credit transaction even after the complainant telling that he did not do that credit transaction, as a result of which the bank was asked to compensate, give back the amount that got debited, and they were also asked to pay rupees 10,000 towards the litigation charges of the complainant. Next, let's look at the case between SpiceJet Limited and Ranju R.A. In this particular case, the complainant booked the air tickets online through yatra.com. The complainant booked the tickets for him as well as for his family members, and the fare was around 75,000 or so. And when the complainant went to the Kolkata airport, what happened? The flight was cancelled, and there was no alternative arrangement made by SpiceJet. As a result of which, the complainant had to go to had to book another aircraft, and they had to book the tickets in another service provider, and they had to shell out the cost for that. So what the complainant did was the complainant made a complaint that the amount had to be returned, and they also wanted a compensation of 1.5 lakhs for the for all the mental agony and physical hurdles that they had to undergo because of the cancellation of the service. So when the Consumer Forum looked into this particular matter, what they felt was like there was deficiency in service. So they asked the airways to pay back the fare as well as to compensate the complainant worth of 1.5 lakh rupees for the mental agony. What the opposite party felt was like, they felt that the jurisdiction was not followed by the complainant while making a judgment. So when they went for an appeal, that the complainant cannot make a complaint in a particular district commission, because if we look at the opposite party does not reside at that particular place, they do not have a branch, and they actually do not carry out any of their work for gain, personal work for gain. So this doesn't fall under the jurisdiction, and the complainant cannot, whatever complaint that they have made, whichever place that they have made a complaint, that is not correct. So this case will not stand. So this was the argument of the opposite party, but the commission made it very clear that it was an online transaction, and the consumer can file the complaint with any of the commission anywhere in India. Not necessarily it should be done only in the place where the opposite party resides or has a branch or has their activity for personal gain. So since it's an online transaction, so this particular rule does not hold good. Next, let's look at the case of Ritwik KR versus Union of India. Here, 4 of the students, they went for an admission with the medical college under the management quota. So what happened? The college gave them the admission under the provisional admission category, and they were told, like, in case their admission doesn't get approved by the appropriate authority, the admission will get cancelled. But all the 4 students were made to pay the fee, the college fee, the tuition fee, as well as they were made to pay the donation. And one of the parent of the student was also made to give a declaration that they will not, they will be okay with the college not returning the fee as well as including the donation in case the admission gets cancelled. After the date of admission got over, out of the 4, 3 of the students got rejected because they did not get the approval from the appropriate authority for admission under the management quota. But what the college did was, the college did not return the college fee, tuition fee, as well as the donation that had been paid by these 3 students. And when this particular case came to the consumer court, the consumer commission felt that this was very, very disturbing. The amount donation and the fee was got even before the admission was given, and the amount that was so very high, and these students had to lose a year because the admission got cancelled after the expiry of the admission date, and they were not even given back, they were not given the fee amount back, though they were not denied of the admission. All these were very, very disturbing from the Consumer Forum's point of view, and they mentioned that the government should come out with more transparent procedures with respect to admission even under the management quota. So that should be there, and they took a very serious note of it, and the college was asked to pay a compensation of rupees 1 crore per students for the deficient service. Next, let's look at the case of Nipun Nagar versus Symbiosis Institute of International Business. Here, the complainant got admission in another institute. The complainant wanted to withdraw the admission from the opposite party, but the opposite party refused to give the amount that was paid by the complainant for the admission. So when this particular case came to the Consumer Forum told that when the admission was cancelled, when a particular candidate wants to withdraw the admission, they will have to be given back the fee amount. The college cannot withhold the fee. They have to deduct the processing fee that they had to undergo, but otherwise they have to return the rest of the fee amount, and they followed the UGC guidelines for this particular judgment. Next, let's look at the case of Fiji versus Shinjini Tiwari. In this case, the complainant paid the fee for 2 years in advance with Fiji. But the complainant's son got ill, as a result of which the complainant's son couldn't go ahead with the course. So they wanted the money that they had paid with Fiji for the 2 years period. When this particular case went to the Consumer Forum told that the Fiji has to return the amount for the reason that the course has to happen in the future, and not only that, the condition of the boy should also be considered in this particular case. In fact, Fiji argued that there were 2 other cases previously. Fiji won in the Consumer Forum, where it was judged that the amount need not be refunded by the education institution. But the Consumer Forum felt that this cannot be done. This is pretty unfair. No one can cite that they were made to, the parent had signed that they are okay that with the non-refund of the fee in case they are going to withdraw the admission. So we cannot take this as the agreement, because these are all like these people are they do not have any say in this matter, and they are forced to give the agreement as such. They are not very privileged in taking decisions whether a particular class should be there or not in a particular agreement. So that cannot be cited as the reason for not refunding the amount. And the Consumer Forum directed the Fiji to refund the money to the complainant. The last case that we have is the Food Safety Commissioner versus Anand Unikrishnan and others. Here, the complainant bought vegetables and other food items from Pantaloon Private Limited in one of the cities in Kerala. When the complainant was used the vegetables, it was actually infested with insects, and when it was consumed without the knowledge, they consumed it, as a result of which they had to undergo illness. So what the complainant did was, the complainant made a complaint with the Food Safety Commissioner, but no action was taken by the Food Safety Commissioner for the defect in the goods, which turned out to be harmful to the complainant. So what the complainant did was, the complainant went to the court for redressal, consumer court, and here the complainant made a complaint against both the Food Safety Commissioner as well as Pantaloon India Private Limited. The judgment actually was in favor of the complainant, and the Pantaloon India Private Limited was in fact made to pay back the amount to the complainant. They had to pay the compensation as well as the litigation charges, but the commission quashed the order against Food Safety Commissioner, because the Food Safety Commissioner cannot be brought into this particular system, because they play a statutory role. They do not provide any service, since they do not fall under the definition of provision of service. A person cannot make a complaint against the Food Safety Commissioner. Thanks for listening.